So, what really happens when a single homeowner decides to take on their entire homeowners association? We're about to dive into a fascinating real-life legal battle that really pushes the limits of an HOA's power.
I mean, think about it for a second. It's a question that gets right to the heart of what it means to live in one of these communities. If your HOA board is staring down a tough choice, do they follow the rules to the letter or do they make a practical exception? What are they legally allowed to do? Well, this is pretty much exactly what happened when one resident, a guy named Brent J. Mathews, saw his HOA board cut a special deal for another homeowner. He wasn't having it. He decided to challenge their authority, and that kicked off a legal fight that would spell out exactly how much power an HOA really has. Okay, so how did this whole thing even start? Let's break down the complaint that got the legal ball rolling. Here it is, straight from the petitioner himself. He's basically saying, hey, the board's own rulebook, their bylaws, doesn't give them the right to create a special workaround to the community's biggest rules, the CC&Rs. It's a pretty direct accusation. The entire case really hinged on this one thing, the well agreement. Sounds kind of boring, right? But this deal was the straw that broke the camel's back, in a story that had been going on for almost a decade. To really get it, we've got to rewind. So let's see how this whole situation began long before Mr. Mathews ever filed his complaint. Because this wasn't some new issue that just popped up. It was an old problem that just kept getting kicked down the road. Okay, so this timeline really lays it all out. This whole mess started way back in 2007, with a well that shouldn't have been there in the first place. 4 years later, the board tries to patch things up with a special agreement, but then the property sells. And in 2016, a new set of buyers, the Kaplans, are digging through the paperwork and, boom, they find this weird deal, and an issue that had been dormant for years suddenly explodes. And that brings us to the moment of truth. This wasn't just about some little rule anymore. Nope, this was about a high-stakes real estate deal that was about to completely fall apart. So the Kaplans basically put the board in a corner. They're all set to buy this house, but then they find this bizarre, possibly illegal will agreement attached to it. So they fire off an email that's pretty much an ultimatum. You guys fix this, or we walk away from the deal. The clock was officially ticking. I mean, seriously, put yourself in their shoes for a second. If you play hardball and enforce the rules, the sale collapses. That could hurt everyone's property values and just create a huge mess. But if you bend the rules to save the sale, you look like you're playing favorites. It's a classic no-win situation. They chose to save the deal. The board ripped up the old agreement and drafted a brand new one just for the Kaplans. This well agreement, too, solved the immediate problem. It let the buyers use the well for free and the sale went through. But in fixing one problem, they created the very piece of paper that would end up dragging them into court. So what was the actual legal argument at the heart of Mr. Mathews' complaint? To really get it, you need to understand the two different rulebooks that were in play here. First up, you've got the CC&Rs. The easiest way to think about these, they're the constitution for the neighborhood. They are the big foundational rules that every single person agrees to when they buy a home there. It's the supreme law of the land. And on the issue of wells, the CC&Rs were, well, crystal clear. Section 326 straight up says no water wells, period. There's really no gray area to argue about here. The well on Lot 2 was a direct violation of the community's constitution. Okay, so the second set of rules are the bylaws. If the CC&Rs are the constitution for all of the residents, the bylaws are the operating manual for the HOA board itself. They spell out exactly what the board can and cannot do. So the petitioner's whole case boiled down to this simple idea. By creating that second well agreement, the board essentially changed the neighborhood's constitution for just one homeowner. And he argued that their own operating manual, the bylaws, gave them absolutely no power to do that on their own without a vote from everybody. And this is where the whole case turns. The entire verdict, everything, hinged on the subtle but crucial difference between two legal terms, a variance and an amendment. So check this out. An amendment is a huge deal. It changes the rules for everyone, and you need a massive 75% vote from all the homeowners to make it happen. But a variance? That's totally different. Think of it as a one-time hall pass for one specific homeowner, usually because of some unique situation. Mr. Mathews claimed this was an illegal amendment. The board said, no way, it was just a variance. And that, right there, was the knockout punch. The judge looked at all the facts and sided with the board. He decided that Well Agreement 2 didn't change the no well rule for the entire neighborhood. It just created a specific, one-off exception for the Kaplans. In the eyes of the law, it was a variance. So how did that one critical distinction, the idea that this was a variance, not an amendment, lead the judge to his final decision?
The judge's logic was actually super straightforward. It was like a checklist. 1, he decided the deal was a variance. 2, he looked at the community rules, the CC&Rs, and saw that they do allow for variances. 3, he checked the HOA's own rules, the bylaws, which say the board can use the powers of its committees. You put all that together, and the conclusion was simple. The board was acting within its power.
And in any legal case, the person making the accusation has to prove it. Here, the judge basically found that Mr. Mathews, the petitioner, just couldn't prove that the board had actually broken any of its own rules.
And so, after all the arguments, all the filings, all the drama, it was over. The judge dismissed the petition. The HOA board won.
And that leaves us with a really big question, doesn't it? This case confirms that HOA boards can have a lot of leeway to make exceptions when things get complicated. So, what do you think? Does having that power make a community more flexible and able to deal with real-world problems? Or does it just open the door for rules to be applied unfairly? It's definitely something to think about. Thanks for tuning in.